We are the Armed Attorneys. Today we're talking about getting loaded and defending yourself.
Oh, this is a good one. We're the Armed Attorneys. Today we're talking about whether or not you lose your rights to self-defense when you're intoxicated. If you're one of the 70% of our viewers who are not subscribed to our channel yet, please subscribe. It really does help us out. You can always unsubscribe later. And before we get started, show your support for the Second Amendment by hitting that like button.
And to start off, we have to start with the disclaimer that, generally alcohol and firearms don't mix, I guess, unless you're Hunter S. Thompson.
Let me get my earbuds on and move your drink.
Yeah, you gotta, I like the safety guy just said, move your whiskey before you start shooting.
But it raises this issue because many states have prohibitions on carrying a firearm while intoxicated in public or even carrying in bars. But we have this situation that comes up of, let's say you're at your house, you're in the safety of your own house, you have a cocktail or two, or you have a drink or two. And what if you become intoxicated legally? You wouldn't drive a car, but do you lose your right to defend yourself? And what are you telling your clients, Emily?
Yeah, generally the answer is no, right? You have every right to be intoxicated within your own home. Some states may criminalize, just the mere possession anytime of a firearm, whether you're intoxicated, but that's going to be very, very rare. But really, that issue is separate and apart from your justified self-defense, right? So what you have is, whether you're in a castle doctrine state or otherwise, did you act reasonably when you defended yourself inside of your home? And that's where intoxication comes in, not as a disqualifier necessarily to self-defense, but were you drunk to the point that you acted unreasonably? The example I could think of is the Girl Scout from next door comes in and you're so drunk you can't tell she's not a dangerous, armed burglar, right?
It comes up often enough to where people think for whatever reason self-defense laws are modified. No, the self-defense law of your state is still going to apply. So if you have that strong castle doctrine protections for, guarding you against forceful and unlawful entry, for example. But what we see juries do is look at the reasonableness that Emily was discussing. They're going to jump in your shoes. And remember, we have that reasonable person standard that they're required to apply when evaluating self-defense. And so they're not looking at a reasonable intoxicated person. They're looking at an ordinary and prudent person in the same situation. And so, what we see a lot of times, though, is if you drink too much, you lose the normal use of your mental or physical faculties. And maybe your conduct isn't conforming to that reasonable person.
Right. And, voluntary intoxication, so that just means you are the one who put substances into your body, generally does not absolve any criminal liability. Right. So that really, I think people like to say, well, I was intoxicated. I couldn't, really make the choice as to whether or not I was going to do this. If you're the one who intoxicated yourself, generally that defense is off the table.
Right. But at the end of the day, it doesn't keep you from defending yourself, but just be wary, because the modified perception of the events going on around you or, your perception of threats, that intoxicated misapprehension, that doesn't give you any extra leeway in court. And that's why we always say, if you're going to find yourself in this situation, you should have a DD, a designated defender.
Yeah, sure enough.
Well, we hope you enjoyed this content. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please continue to question and comment below. Until next time, we're the Armed Attorneys.